Warm greetings everyone. I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. In the present module, we will discuss about guardianship under Muslim law. Dear learners, we shall discuss the following segments in today's lecture. Introduction, classification of guardianship under Muslim law, guardianship vis-a-vis custody, powers of a guardian, removal of a guardian, and then conclusion. Dear learners, let's begin with a brief introduction. A guardian is a person who has assumed the care and protection of another person and is responsible for all legal decisions on behalf of that person and his property. In the present module, we will learn about the concept of guardianship under Muslim law. The Quran has provisions for guardianship and parentage in a number of different verses. Guardianship under Muslim law is known as vilayat. A child is known as a wald in Urdu, and the Holy Quran describes a wald as a blessing regardless of gender. Furthermore, it states that the person should be satisfied and happy with whatever the situation may be because they are a blessing. In the case of Sayyid Muhyiddin versus Khatija Bai, 1939, the court observed that the power of guardianship is given to the parents or the guardian because it is expected of them to act in the interest of the child. There obviously exists a trust relationship between the minor child and the parent. But the relationship between the guardian and the child is fiduciary in nature. This is to ensure that the minor child is not acting unfavorably in their own interest. Therefore, assuming that the minor child is incapable of maintaining himself, there is a need to resort to the appointment of a guardian who shall be an adult and shall be capable of making decisions on behalf of and in the interest of the minor child, be it a girl or a boy. Who is a minor? A minor is a person who has not attained the age of majority. Under Muslim law, the age of puberty is considered to be 15 years. And a child who has completed 15 years of age is considered to be a major. It is pertinent to note that in India, the age of majority is governed by the Indian Majority Act 1875. According to Section 3 of the Indian Majority Act 1875, someone domiciled in the Republic of India who is below the age of 18 years is a minor. A minor is assumed to have no capacity to protect his or her own interest. The law thus requires that some adult person must safeguard the minor's person or property and do everything on his or her behalf because such a minor is legally incompetent. Who is a guardian? A person who is authorized under the law to guard the person or property of a minor is called a guardian. Under Muslim law, guardians are needed for the purpose of protecting the minor's person and property. A guardian under Muslim law has the power to perform the marriage of a minor. As regards the guardianship of illegitimate children, a Muslim father has no right over the illegitimate children, and he is not the guardian of his illegitimate children. Even the mother is just the custodian of the illegitimate child and not the guardian. Thus, under Muslim law, an illegitimate child belongs legally to neither of its parents and is considered to be filius nullius. But for the purpose of securing its due nourishment and support, it should, until it has attained the age of 7 years, be left in the charge of the mother. After that age, it may make its own choice with which parent it will reside, or it may live apart from them altogether. In Gohar Begum versus Suggi alias Nazma Begum, a case of 1960, the Supreme Court held that the Muslim law, the mother of an illegitimate female infant child is entitled to its custody. The refusal to restore such a child to the custody of its mother would result in an illegal detention of the child within the meaning of Section 491 of the Criminal Procedure Code. Now, it's important to understand guardianship vis-a-vis custody. Guardianship and custody, also known as hizanat, of a child are two distinctive concepts. A guardian is a person who has taken on the responsibility of a minor's care and protection and who is in charge of making all legal decisions on that person's and his property's behalf. Custody of the child simply means a physical possession of the child upon a certain age. A guardian need not be a custodian of the child. Custody could be for a short duration or for a specific purpose. But guardianship is more permanent in nature. Custody might not be with the father, but guardianship is always with the father in Muslim law. Although the mother is not the natural guardian of the child under Muslim law, she has a right to the custody of the child until the child reaches a specific age. But the father exercises guardianship over the minor throughout the entire interval of the minority. Under Shia law, a mother's right to the custody of the minor children extends until a son is 2 years old and until the daughter attains the age of 7. Under the Hanafi Sunni law, a mother is entitled to the custody of her son till he reaches the age of 7 and in the case of a daughter till she attains puberty. The mother's right continues even if she is divorced from the father of the child unless she remarries, in which case the custody belongs to the father. This, however, is not a rigid rule and the court can deviate if the welfare of the child so demands. In Irfan Ahmad Sheikh versus Mumtaz, 1999, the custody of a female child was given to the mother. The mother's marriage with the child's father was dissolved and she remarried a person who was not within the prohibited degree of relationship with the child. The court nonetheless gave custody to the mother and the child had also expressed a desire to remain with the mother. In Abul Kalam versus Akhtari Bibi, 1988, the court observed that even though As a natural guardian, the father may have prima facie right to the minor's custody. This may be negated if the infant's welfare lies in keeping him with the mother. The court held that the welfare of the child is of paramount consideration, and for a child of 2 to 3 years, undoubtedly, the mother would be the proper person to have custody of the child. And accordingly, the court directed that the custody of the child should be given to the mother till the child completes the age of 7 years. Thereafter, the father may get the custody of his son. Now, let's understand the concept of muhrim. The custody of a Muslim child cannot be given to a person who is not a muhrim. Muhrim means a person who is in relation to the child and is within the prohibited degrees of relations with the child. That is, a person who is unfit to marry the child. Under Muslim law, guardianship can be classified into 3 types. Firstly, guardianship of a person. Secondly, guardianship of property. And thirdly, guardianship in marriage. Marriage is often contracted on behalf of minors by the guardian. The father can impose the status of marriage on his minor children. This power of imposition is named Jabr, the abstract right of guardianship or vilayat. And therefore, the guardian so empowered is known as wali. Now, let's understand the classification of guardians. Muslim law recognizes the following types of guardians. Number 1, a natural or legal guardian. Number 2, testamentary guardian. Number 3, guardian appointed by the courts or statutory guardian. And lastly, de facto guardian. Firstly, natural or legal guardian. A natural guardian is one who has the right to regulate and supervise the activities of a minor. The father is recognized as the natural guardian of a child under all the schools of Muslim law. And the mother is not considered a natural or other guardian even after the death of the father. The father is considered to be the only natural guardian of the child, even if the custody of the child is not with him. Even then, he has control over all the decisions relating to the child. A natural guardian is additionally known as a legal guardian. But in the absence of the father's executor might also act as a legal guardian. The executor could be one who is appointed by the father or grandfather to act as the guardian of his minor child on his behalf. That is, the person who will be the next in turn to take over the guardianship in the absence of the father. But the father, if he is alive, shall be the supreme and only guardian, who shall have the right to make decisions on behalf of the minor child. In Shia law, the legal guardian who comes next in turn shall be the paternal grandfather, that is, the father's father. Moreover, the role of the executor of the father shall not begin if the father is present, and if the father is absent, then the paternal grandfather shall be acting as guardian. Thus, the natural guardian of a minor in order of priority is firstly father, then executor of the father, then paternal grandfather, then the executor of the paternal grandfather. Now, under Muslim law, in the absence of any of these persons, no one else is recognized as the natural guardian of a minor. Under Shia law, in the absence of a father, only a paternal grandfather could act as a legal guardian. In the presence of a paternal grandfather, the father's executor has no right to act as the legal guardian of a child. Now, as far as mother as a guardian of a minor is concerned, Tahir Mahmood explains that under Muslim law, guardianship of a person in relation to a child belongs primarily to its father, the mother being only a preemptive right to keep the father away for a legally prescribed period only from a particular aspect of the guardianship of the person, namely the custody and physical upbringing of the child. In the case of Ghulam Hussaini Qutbuddin Manner versus Abdul Rashid Abdul Razak Manner, the Honorable Supreme Court held that a mother of a minor cannot be appointed as his guardian to accept the gift on his behalf during the lifetime of the minor's father. Now, my dear learners, next is testamentary guardian. A guardian appointed by will is known as testamentary guardian. This appointment is carried out by the father of the minor child, and under a circumstance where the father is not alive, the paternal grandfather shall have the authority to decide the guardian. A testamentary guardian is also known as Wali, Amin or Qayam Muqam in both Shia and Sunni. The testamentary guardian can be appointed by the father. In Sunnis, in the absence of the father and his appointed executor, the grandfather is empowered to appoint a testamentary guardian. In Shias, the guardian appointed by the father would only be valid if the grandfather is not alive. Otherwise, the grandfather is empowered to appoint the testamentary guardian. In both Shias and Sunnis, the mother has no power to appoint a guardian for her children except in two cases. Firstly, she has been appointed executrix by the father's will. Secondly, she is the owner of a property that will be devolved to her children after her death. A mother can be appointed as a testamentary guardian or executrix of a child by the will of the father or grandfather. In Sunnis, a non-Muslim mother can be made a testamentary guardian, but in Shias, a non-Muslim mother cannot be appointed as a guardian. A profligate person who is having immoral behavior cannot be appointed as a guardian because that will not be good for the welfare of the child. A testamentary guardian shall accept the guardianship either expressly or impliedly. Once the guardianship is accepted, it cannot be refused or renounced except with the permission of the court. In the case of Atika Begum versus Muhammad Ibrahim, it was held that in the presence of a grandfather, the father has no right to appoint a guardian for a minor. Now, next is guardian appointed by court. In the absence of a natural and legal guardian, the court is authorized to appoint a guardian for the sake of the minor's person or property. The appointment of a guardian by the court is ruled by the Guardianship and Wards Act 1890, which is applicable to all Indians, irrespective of their religion. Such guardians are also known as statutory guardians. Dear viewers, let's discuss limitations of guardians appointed by courts. Though a guardian appointed by the courts has the full right to take care of the property of the minor, certain limitations are also prescribed, for which prior permission from the courts is required. In cases of mortgage, transfer by sale, transfer by gift, etc. of the minor's property, prior permission of the court for such alienation is necessary. Next is de facto guardian. A de facto guardian is a person who is neither a legal guardian nor a testamentary guardian or statutory guardian, but has himself assumed the custody and care of a child. According to Tayyabji, a de facto guardian is an unauthorized person who, as a matter of fact, has custody of the person of a minor or his property. A de facto guardian could be a person who has no authority over the guardianship, but under the circumstances, they have the responsibility to act as the guardian of a minor. A de facto guardian has responsibility for the minor's welfare as well as his or her property, but has no rights against the minor or his property. Alienation of a minor's immovable property without the authority of the court by a de facto guardian is void. For instance, A is a 12-year-old minor child who lives with his mother and maternal grandmother at his grandmother's house. A's mother died due to several diseases, and A was taken care of by his grandmother. In this case, the maternal grandmother of A becomes the de facto guardian of A, although the grandmother has not been appointed as the guardian by the court, nor is she appointed by the parents of A as the guardian. She has to take care of A because she is the only relative of A. Therefore, a person who assumes the care and protection of a minor because of any circumstance or a moral obligation and not because of any legal mandate is called a de facto guardian. Moving further, now I will throw light upon the powers of a guardian. A guardian under Muslim law has following powers. Firstly, he can sell the movable property for a minor's essential necessities like food, clothing, nursing. He can alienate immovable property only in exceptional circumstances, and fraudulent transactions are voidable at the instance of the minor. He can lease the property for the benefit or needs of the minor, but the duration of the lease can't be more than the duration of the minority. He can carry on the business of the minor, but like a prudent man, he would have carried on the business. In an emergency, he can also procure debt on behalf of the minor. However, debt raised in the absence of a necessity would not be binding on the minor. Where there is a conflict in the application of the provision of personal law and the Guardians and Wards Act 1890, the latter will prevail. Next is removal of a guardian. A guardian de jure, that is appointed by law, or de facto, is removable by the court if it is necessary for the interest of the minor. The court can remove the guardian on the following grounds: abuse of his trust or continued failure to perform the duties. Thirdly, incapacity to perform the duties of the trust. Fourthly, ill treatment or neglect to take care. Next, continuous disregard of the provisions of the Guardians and Wards Act. Also, having an adverse interest in the faithful performance of his duties. Next, conviction of an offence. Also, ceasing to reside within the local limits. And lastly, insolvency or bankruptcy. Next is cessation of authority of guardianship. Under Muslim law, the powers of a guardian of a minor cease firstly by death, removal or discharge. Secondly, by the court assuming the superintendence of the person. Thirdly, by the ward ceasing to be a minor, etc. The conflict between the Guardianship and Wards Act 1890 and personal laws. If the provision of the personal law is contrary to the provision of the Guardians and Wards Act 1890, the latter will always supersede the prior one. In the case of Rafiq versus Bashira, the court held that Section 19 of the Guardians and Wards Act 1890 will prevail over Section 17 of the Muslim Personal Law Application Act 1937. My dear learners, from the foregoing discussion, it may be summed up that guardianship under Muslim law is governed by Sharia law. The main objective of guardianship is to ensure the welfare and protection of a minor's person and property. A minor child is incapable of taking care of himself or making decisions. There is a need to have a person to take care of the child, provide support and love, and provide all the basic requirements for the child. Muslim law makes a distinction between guardian of the person, guardian of the property, and guardian for the purposes of marriage, that is Wilayat al-Nikah, in the cases of minors. Different schools of Muslim law differ in many provisions, but they all maintain coherence in guardianship as the welfare of the child and protection of his property are of utmost importance. Further, the Guardians and Wards Act is the legislation passed by the Parliament that deals with the laws and processes related to guardianship in India. With this, we come to the end of today's lecture. Thank you very much.